One of the biggest worries for anyone thinking about divorce or separation is likely to be about the children, where they will live, how they will continue to have a meaningful relationship with both parents. These are often not easy questions and feelings run high. Against that background, resolving financial issues such as child maintenance or school fees can sometimes feel overwhelming. Help is at hand, and there is a lot of support and information available for parents facing these issues. The children section of this website is a good place to start and provides links to a number of useful tools and resources which may help you to reach an agreement. It may also help to discuss these issues with a solicitor so that you know where you stand. And I'd like to set out some of the legal remedies available to you. If parents can't agree where the children will have their main home or how they shall spend time with the other parent, there are a number of options. Sometimes mediation can help. This involves working with a qualified mediator whose role is to help the parents to reach an agreement over the course of a number of joint meetings. We can direct you to a local mediation service, and it's important that independent legal advice is taken outside of the meetings. If an agreement can't be reached, another option is to make an application to the court for a child arrangements order. This enables the court to intervene and make an order setting out where a child shall have their main home and a framework for the child to spend time with the other parent. These orders can be as detailed as they need to be and can be enforced by the court if they're not complied with. But even within the court process, there is a strong emphasis on trying to help parents reach an agreement. It's important to appreciate that when a court is considering any question regarding a child's upbringing, the welfare of the child will be the paramount consideration. The child's independent wishes will also be taken into account, but only if they have sufficient understanding of the issues in the case and the consequences of their decisions. Those views are independently ascertained by a court-appointed expert from an organisation called CAFCASS. Another difficult question is how much child maintenance should be paid by one parent to the other. In most cases, financial support for children is dealt with by applying the statutory formula used by the Child Maintenance Service. This identifies the resident parent, that is the parent with whom the child lives for the majority of the time, and the non-resident parent. A formula is then applied to the non-resident parent's income, which produces an assessment, and that is the figure which should be paid. In straightforward cases, another way to approach this, rather than making an application to the Child Maintenance Service, is to use their online calculator in order to agree the amount that should be paid. This avoids having to pay the application fees and collection fees, and this calculator can be found by visiting the Child Maintenance Options website. Please also bear in mind that this can be an extremely technical area of law with many traps, and it is important to take advice before deciding which approach is best for you. Sometimes the situation is more complicated, possibly because the non-resident parent's income exceeds £3,000 per week, this being the maximum gross income the Child Maintenance Service can take into account. There may also be issues regarding payment of school fees or where a child has special needs. In these circumstances, an application can be made to the court, either for top-up maintenance or for some other financial provision. Understanding the legal position in relation to these issues is extremely important and will help you to have positive and well-informed discussions with the other parent, enabling you to work together in the children's interests.